Hello, and welcome to Beyond the Lunch. I am your host, Attorney LaConnie Murray, owner of Off the Mark IP Solutions, where we help clients throughout the United States with trademarks, copyright, and business development solutions. Thank you so much for joining me. If you're catching the replay, let me know in the comments that this is the like I said, for joining me on this impromptu video. But I had to come on. Like when I heard this, I was like, we got to talk about this. Which, you know, my favorite thing in the world to do is to be able to explain trademarks using real world examples. This is amazing. So check it. So I don't know about you guys, but I know Double Dare. Like we used to watch Double Dare real hard when we were at my dad's house, you know, in the summertime when we had cable and we would watch it. And then they came up with like different versions of Double Dare. So Double Dare is a Nickelodeon kids show where they had like these programs where they would ask you questions, and then if you had a dare, they had these outrageous dares you would have to do. I thought they were pretty gross, but it was still really interesting to watch. So it's owned by Viacom, and I think Double Dare was owned from like 1987 to 1993. It was owned real heavy, and then it went off the air. It went off the air, then it came back. They revived it in 2000 for a brief period, like from January to November 2000, and then they had reruns going into 2001. They let the trademark expire. They had a trademark for Double Dare, and they let it expire after the revived show went away. Hey, Aussie. But in the meantime, so now it's 2018, and they decided to bring the show back. But, here's the but. In January of this year, there's a company called Armstrong's Interactives. They actually filed for a trademark of Double Dare in January, and then they filed a second trademark in May for Double Dare Live. And when Nickelodeon brought back Double Dare in June of this year, so just a month after they filed that second trademark, they were hit with a cease and desist that said, yo, pump your brakes, stop it. You can't register this mark. And so let's just talk about that real quick. So the Armstrong Interactives is owned by Charles Armstrong, and they filed what is called an intent to use application. And that intent to use application says that we're not using this trademark now, but we have a bona fide intent to use this as a trademark. That means like we're really going to use this as a trademark. Like, so we just want to go ahead and do what we need to do because we're going to use this as a trademark. And so you have that on the one hand, someone that's filed a 1B application, and typically the purpose of that intent to use application is to give you priority over someone else who hadn't filed yet. And so typically I advise my clients to use that when they are in their product development phase, and they're still getting things to market. It's not quite ready for market, but they're doing everything they need to do to get it to market. And I advise them to use this registration in order to protect their standing. Okay, so make sure that no one else beats them to the trademark. So that's the intent to use application. So he filed 2 of those intent to use applications. So Nickelodeon responded back to that cease and desist letter with a lawsuit. They sued for declaratory judgment against the Armstrong Interactives, basically asking the court to say, hey, look, who owns this trademark? We say that we own this trademark. And they say that they own the trademark for a couple of reasons. One, they said that this dude has a history of squatting on old popular TV shows and just doing nothing with the marks, just registering them and hoping that they can sell them back to the company. And so that's one of the defenses. And the second one is, look, I know that we didn't renew our registration, but we've been using this mark like heavily. We've been using it. We never stopped using it as it relates to programming, live shows, merchandise. That being said, I want you to take away at least 2 points from this quick video. So when it comes to trademark registration, the first thing you want to learn from Nickelodeon is that you have to maintain registration, because it's cheaper. If they would have just maintained their registration, they wouldn't have to bring a lawsuit and spend that extra money in legal fees. But with trademarks, it's not just file it and it's done. You don't just file your trademark registration and forget about it. Remember, trademarks protect brand identifiers. That is the source of a good or a service, right? Hey, Jessica. So if it's not being if it's not tied to a good or a service, then there is no trademark. And so every few years, the USPTO office wants you to submit proof that you're actually using it, okay? So if you register your mark after between the first 5 and 6 years, you have to submit proof. And then after that, every 8 to 10 years, you have to show proof that you're actually using this mark as a trademark. So that's thing number one. So if you're using it, just go ahead and fill out the paperwork and keep your registration up. And that's one of the services that we provide here at Off the Mark. We do that for you. The second thing I want you to know, I really want to talk about this. Okay, so if you listened to me just a few minutes ago, Nickelodeon said that they said two things about Armstrong's intent to use application. One, they said that, this is just something that he does. He has a history of squatting on these trademarks, hoping to negotiate a settlement or something to get paid for selling them back. Intent to use, like I said, they want to make sure you have a bona fide intent to use this application. So they do like an analysis. You can't just file it. So do an analysis to see if you really do have a bona fide use. And so we're going to go over and break down some of those things that they look at, okay? So the first thing you need to know when you file an intent to use application, it's not a bookmark. Okay, it's not a bookmark. It's not something that you say, hey, let me register this just in case I decide to use it. That's not how it works. Just because you may use it, you don't file an intent to use application. You file an intent to use application because you will use it. You have plans to use it, not because, I might use this in the future and I want to make sure that no one else uses this. That's not what you do. And if you do that, then they're going to say that you don't have a bona fide intent to use application. The next thing they want to know when they're doing this analysis, let's say someone challenges your intent to use application, they want to know, do you have like an actual product or prototype or service or something that this is attached to? If not, that can count against you. And when we're going through these points, you want to, hey Jasmine, when you're going through these points, you want to make sure that, I want you to know that they look at everything as a whole, not just, do you have this point, do you have that point? They look at everything as a whole to determine whether or not you have an intent to use application. So the first thing is, are you actually reserving it because you intend to use it, or are you reserving it to make sure that no one else uses it? That's the first thing. The second thing is, do you actually have a prototype or a product or a service or something that this trademark is going to be attached to? And some people say, well, it's an intent to use application, so I don't have it now, but I'm working on it. And that's another one of the points that they look at. Like, what have you done since you filed your application? Like, are you actually getting your product, your service ready for market, or are you just chilling? That's one of the things they look at. And then they want to know, like, is it feasible? Sometimes you have this mark and, it's associated with a good or a service. So now what they're going to do is actually look at your good or service that you have your trademark associated with. They want to know, is that even a feasible service? Like, is that even a feasible trademark? Like, say, for example, in the service business, if you are filing a trademark that's something related to in the legal industry, or maybe the medical industry, maybe you're saying that you're going to use your mark associated with legal services, right? But you're not a lawyer. So it's not feasible for you to use that mark in that way. You see what I'm saying? Like, they want to know if it's feasible. And like, do you have any history in this industry? I saw there was a case, it was like Swatch versus iWatch, and they had to do with smart technology and Swatch. iWatch filed an intent to use application. Swatch or S-Watch said that, they challenged their intent to use registration, and the courts agreed with them because one of the things they looked at, they said this guy had never had any history in this industry. Like, he never had anything to do with watches and technology or anything like that. That's just one of the things, among others, that he looked at. And also, you hear a lot about target market when you're in business, right? USPTO looks at that as well. Like, you say you want, this is a service or a good that you're providing, right? Who are you selling it to? Who is your market? What have you done to make sure that you know where they are? What have you done to make sure you can reach them? What have you done to make sure that they will know about the product that you serve? Like, have you identified who are they? That's one of the things that they look at. The next thing they look at is, Like, have you made any firm decisions? Like, if you need to decide whether or not you're going to provide this service, you know, or provide it this way, like, have you made any, when it comes to business, have you made any real decisions about how your service or good is going to move forward? And like I said, what steps have been taken since you filed the application? Did you file the application, now you just sit back chilling, or are you filing the application and you're talking with designers and you're doing market research and you're getting your product prototype together for your product and you're building your service? Like, what are you doing? That's the main thing they look at when you're filing this intent to use application, okay? I want to talk about this real it's because if you have signed up for the Ultimate Trademark Basic Blueprint, one of the modules in there talks about dead and abandoned trademarks. And so this is like a real world example of what we mean when we talk about dead and abandoned trademarks, because just because it's showing up dead in the system doesn't mean that it's actually available. Okay? Same thing. So dead is not available. So let's put it this way. So it depends on the circumstances. So what I mean by that is dead does not automatically mean available. And you can, like I said, you can go to the Ultimate Trademark Basic Blueprint and take the course. It's only $47. We break down trademarks, and we talk about dead and abandoned trademarks, and we also talk about the trademark clearance search. So it's really awesome. I'm going to bounce. Hopefully you guys find that helpful, because I know a lot of people out there do their own little trademark clearance search and they see dead or abandoned, they're like, yay! So this is just one more thing to think about.